Hello, I'm Kuldeep Clair, and I'm a consultant solicitor with Sterling Lawyers, and I deal with civil litigation and debt claims here. I'm just going to have a quick talk about how we deal with debt claims and how we can assist you if you're trying to pursue debt claims or money claims in particular from any debtor who owes you any money. We're dealing with simple claims here for money at the moment, although we deal with other kinds of civil litigation obviously as well. Basically, if someone owes you money, then the first step to take is to instruct us to deal with some kind of correspondence against that debtor, what we would call a letter before action. That's the first step that we would take when we're pursuing someone for money. We would send a letter before action, as we call it, which is basically a letter asking for that money and warning the other person that we would commence proceedings against that person if that money is not paid within a certain period of time. Usually that would be about 10 days, 14 days, something of that nature. And we would warn them that if proceedings were commenced, that we would also claim court costs, legal costs, and statutory interest if court proceedings became necessary. If we didn't receive a response to that letter before action, then we would probably commence those proceedings, and that would involve obviously extra costs as well, and we would claim some of those costs, although we wouldn't recover all of those costs, but most of those costs or some of those costs from the debtor. We would issue the claim. That would involve certain costs. It involves a court fee, for instance, as well, and we would claim some of those costs from the debtor. Once we've issued the claim, that would usually be in the county court, unless it's a very big claim. Then the claim would be issued by the court. It would be sent to the debtor by the court, and the debtor would have about 14 days to respond to the claim by sending an acknowledgement or a defence. If no response was received, then the debtor would be liable for getting a judgment against them. And they would receive a judgment in default, as it's known, and what that means is it's a judgment in default of a defence having been received. If that was to happen, it would be a relatively simple procedure, and that means that a court order would be issued saying that the debtor has been found liable for the money in question. If a defence was filed, then the court procedure is a little bit longer, and we haven't really got time to go into that now. But if a judgment was obtained, then the next step would be, if the debtor did not pay that money immediately, next steps would be to try and enforce that judgment by taking one of the many enforcement steps that are available to enforce that judgment. And we don't really have time to go into all of those enforcement steps that are available, but there are many kinds of enforcement steps which are available to enforce judgments against debtors. So, if you do have any kind of claim which you want to make against someone who owes you money, please feel free to contact us, and we can discuss your individual circumstances and help you with your situation and hopefully recover money that's due to you. Thank you very much.